Okay, Autozone dealt with 412356F, and I've done a bunch of videos about that. And one of the danger zones with the Autozone Supreme Court case is that if you're working a light duty position, you're kind of in, you're always under a fishbowl when you have a work injury, but you're under the super fishbowl when you're in a light duty position. And so the problem with that AutoZone created is if you're terminated for cause, or at least the employer can make an argument that you're terminated for cause, then that might be a reason why you're not entitled to comp. So let's say you're working a light duty and it's a sedentary type job, and you get terminated because you're late by X number of minutes, or you no call no show more times than is allotted, then you would be terminated for cause. And post AutoZone, whether or not you could find, because maybe you're in a sedentary position because you have a major back injury, or you have a leg injury or a foot injury, and you're recuperating from your work injury. You're still actively treating, etc., or perhaps you're waiting for a surgery to be undertaken. But after AutoZone, basically they'd say, hey, if you're terminated for cause, if that's the reason why you're not working, whether or not you also are not working because of the conditions allowed in your workers' comp claim, in that case you would not be entitled to temporary total disability compensation. And my concern with that situation is we're going to be making the industrial commission kind of have to do, particularly if there's a situation where somebody was terminated and it allegedly was for cause, we're going to make the industrial commission be basically investigators as to whether or not that termination was justified. And I don't know if that's really the proper role for the industrial commission to be digging into these employment situations, because that's not, workers' comp is not really dealing with employment law, so to speak. I mean, you're thinking workers' employment law, that's, what do you mean, Kip? But employment law is like a totally different thing. You're dealing with wage and hour violations, you're dealing with discrimination type things and those sorts of things. Workers' comp is really just focused on, has there been a work injury? Is the work injury causing this? Is this treatment related to the conditions? Is this condition that you're requesting, is it related to the work injury? That sort of thing. Those are the kind of issues, questions, medical issues, medical questions, legal questions that the industrial commission is geared towards handling. So like whether or not somebody was terminated properly, whether it was just a rightful termination or a wrongful termination, that's more of like something that, like the unemployment, when you're pursuing unemployment, they do these kind of analysis, and it would be more appropriate for them to be weighing these sorts of things. So this AutoZone kind of took some of that, they took that and they kind of stuck that in the commission's lap, and they kind of have to be these arbiters of, well, that termination was not justified, or it was. And I'm not sure it's the most appropriate kind of thing to do. But we have a full commission order published on February 6th of 2025, and it deals with kind of that situation. Somebody's working a light duty, and then they get injured, and then they return to work for light duty. And then what ended up happening in this full commission was that the employer terminated this person for getting, I guess they got too many points in their attendance policy. So, I don't know how the different employers have different point systems, but in this instance they had, I guess, 9 points that you can accrue. And so this person, allegedly by the employers, got more points, over the threshold, and because they went over the threshold of this attendance policy, then the employer went ahead and terminated this person. So, and then this person, they're no longer working, they can't get another job, possibly because of their work injury, and so they file for temporary total disability, and they're also otherwise qualified to receive temporary total disability, so they haven't been found MMI. They're being certified by their treating physician of record. So they pursue comp. Comp was denied at the SHO staff hearing. So then this injured worker filed for a request for a full commission hearing, and so we have this decision. And so what the full commission, they heard the facts, and they basically said, okay, they basically determined it wasn't a justified termination. So the employer, they could terminate you, but the industrial commission basically determined that the employer didn't follow its own progressive disciplinary process, which is laid out in their attendance policy. So the employer is saying, hey, you violated the attendance policy, but the full commissioners are saying, yeah, but you guys violated your attendance policy by not following this progressive disciplinary process. And then the other thing the full commission, the conclusion they came to is this person actually did, even if you would have followed the progressive disciplinary process, this person didn't actually accumulate sufficient points to be terminated in the first place, by their calculation. So therefore, it was an unjustified termination, or it was a wrongful termination, and therefore the person was entitled to comp on that, in that basis. And it's kind of a weird, again, that's kind of a weird thing for the industrial commission to be doing that. My question would be, did they take that information? Can they go, if like unemployment, like let's say you file for unemployment, because to get unemployment you have to be able to work. If you're on light duty restrictions, you can work, then perhaps this person would be able to file for unemployment. I don't know why you'd want to file for unemployment after getting compensation, but I wonder if they could, because they're offset, but if they could go over there and say, hey, see, it was wrongful discharge, or if there's, they could take this as kind of, evidence that the employer, this is a wrongful retaliation sort of situation, some kind of employment lawsuit. It's interesting. I suspect you wouldn't be able to use this as evidence of that, but I don't think you could use the industrial commission's decision as a as a probative evidence or some kind of influential kind of evidence to come to that conclusion. But yeah, it's interesting. So it's a good outcome for this injured worker, because it sounds like they got screwed over. And so I like it when injured workers, because this workers' comp stuff's just beastly, and it's nice when the injured workers win. So in this case, they got one over the employer, and I like that. And it looks like the employer was trying to get one over on them, and they lost. So good for the injured worker. But yeah, that's this full commission hearing order. But as I say at the end of all these scintillatingly super interesting videos, I'm sure, this stuff is super duper complicated, so you need to get a workers' comp attorney involved with your situation in case. Do not do this alone, and because if you do this alone, you're asking for trouble. So yeah. But ask your friends, families, coworkers, neighbors, who do they recommend. Talk to an attorney or multiple attorneys. You really want to suss out the best attorney for you, because you could get another attorney potentially, but it's going to be harder to get another attorney to look at your case after the fact. If you have somebody else representing you and you fire them, it's going to be more difficult to get another attorney to want to get involved with your case, because usually other attorneys don't want to clean up other attorneys' messes, and that's kind of, a lot of times that's what happens. But yeah, so find the best attorney for you, and what that requires for you to do is just talk to multiple attorneys and law firms. So anyways, this is Kip from Malik. Stay safe, don't get injured, and I will talk to you next time.